You're in the United States on an H-2B visa, working hard and building a life. A common question we hear is, can I switch my H-2B visa to another visa without leaving the country? The short answer is yes, it is often possible. But this is a critical moment where many people make serious and sometimes irreversible mistakes. The process is far more complex than simply finding a new job. First, you must understand that your H-2B visa is tied directly to your specific employer for a specific job in a specific location. It was approved based on their temporary need for your labor. This means you cannot just quit and start working for someone else or decide to change your status on your own. Doing so would violate the terms of your visa and immediately put you out of legal status. To make any change, a qualified U.S. employer must first agree to sponsor you for a new visa and file a formal petition on your behalf. This is the non-negotiable first step. Depending on your qualifications and the job offer, you might be able to switch to another non-immigrant visa, like an H-1B for a specialty occupation if you have a bachelor's degree, or even begin the long-term process for a green card. But each path has its own strict rules and must be followed perfectly. Let's break down the timeline of what this process actually looks like, step by step. Phase 0 is the pre-check. Before anything is filed, you must have a legitimate job offer from a new employer who is eligible and willing to sponsor you. You must also confirm that you are personally eligible for the new visa category and that you are not inadmissible to the U.S. for any reason. This is the foundation for everything that follows. Next is Phase 1, employer preparation. Your new employer, often with their attorney, will begin gathering the required evidence. For an H-1B visa, this includes filing a labor condition application, or LCA, with the Department of Labor. They must prepare a detailed job description and assemble documents proving the company's legitimacy and its ability to pay you the required wage. This phase can take several weeks. Phase 2 is the official filing with U.S. Citizenship and Immigration Services, or USCIS. Your employer will file Form I-129, the petition for a non-immigrant worker. If you have a spouse or children who also need to change their status, you will typically file Form I-539 for them at the same time. You must decide between regular processing, which can take several months, or premium processing, which guarantees a decision from USCIS within 15 calendar days for an additional government fee. Phase 3 begins after your case is filed. Within a few weeks, you should receive a receipt notice from USCIS with a case number. This is proof that your application is pending. In some cases, you may be scheduled for a biometrics appointment to have your fingerprints and photo taken. Be prepared for a possible request for evidence, or RFE. This is a common request from USCIS for more information, and you typically have 30 to 90 days to respond. Phase 4 is the decision. If your case is approved, you will receive an approval notice that states the start date of your new status. You cannot begin working for the new employer until that date. If your case is denied, the notice will explain why. A denial can be devastating, and your options may be limited to leaving the U.S. or, in some specific circumstances, filing a motion to reconsider or a new petition. Phase 5 covers critical cautions about your status. The most important rule? Do not start the new job until your change of status is approved and the new validity period begins. Working without authorization is a serious violation. Also, watch your H-2B expiration date closely. If your current status expires while your new petition is pending, you can generally stay, but if the petition is denied, you begin accruing unlawful presence immediately, which can lead to 3 or 10-year bars on re-entering the U.S. Phase 6 is an alternative path. Consular processing. Instead of changing status inside the U.S., your employer's petition is approved and sent to a U.S. consulate in your home country. You would then travel home, complete the DS-160 online visa application, and attend an interview. While this avoids the complexities of unlawful presence, it introduces its own uncertainties, like interview wait times and the risk of administrative processing, which can delay your visa for weeks or months without a clear timeline. Finally, Phase 7, onboarding after approval. Once you are authorized to work in your new status, you will complete a new Form I-9 with your employer. You may also need to visit the Social Security office to update your record. It is vital that you keep copies of every single document, petitions, receipt notices, approval notices, and your I-94 record. These are your proof of legal status and work authorization. Now, let's highlight the most common pitfalls. The biggest mistakes include filing the wrong forms, filing too late after your H-2B status has already expired, working for the new employer before you get official approval, and traveling outside the U.S. while a change of status application is pending, which can cause the application to be considered abandoned. While you are not legally required to have an immigration attorney, these complexities are why most employers use one. Immigration laws are incredibly detailed, and a small mistake on a form or a missed deadline can jeopardize your entire future in the United States. An experienced attorney helps ensure the process is managed correctly from start to finish. So, to recap, a successful switch requires a qualified and willing employer, your own eligibility for the new visa, filing the correct documentation with USCIS, applying before your current status expires, and never working without authorization. Remember, one wrong move can not only lead to a denial, but can also affect your ability to return to the US in the future. The stakes are incredibly high. Always verify your specific situation and understand the entire process before you make any decisions that could impact your status. Follow H-2B Success Blueprint for real guidance on how to work, earn, and build opportunities in the United States. This content is for educational purposes only and is not legal advice. An individual's eligibility for any immigration benefit always depends on the specific facts of their case.